So hello, very good morning everyone. So today we are going to discuss about the High Court. Okay. So the High Court of India, right, occupies the top position in the judicial administration of a state. Okay. The High Court originated in 1862 when there were high courts set up at Calcutta, Mumbai and Madras. Okay. And then also in Allahabad. Okay. Now, in the course of after 1950, the High Court existing in a province became the High Court for the corresponding state. Okay? So the Constitution of India provides for a High Court for each state, but the 7th Amendment Act of 1956 is authorized the Parliament to establish a common High Court for two or more state or for two or more state and the Union Territory. So at present, how many High Courts are there? At present, there are 25 High Courts in the country, and out of this only 3 high courts have jurisdiction over more than one state. Okay? And among the 8 union territory, Delhi alone has a separate high court. Okay? The union territory of Jammu and Kashmir and Ladakh have a common high court. Okay? So article 241 to 231, sorry, article 214, okay, article 214 to 231, part 6th, okay, part 6th of the Constitution deal with the organization, independence, powers, procedure, jurisdiction and so on of the High Court. Okay. So every High Court, it consists of a Chief Justice and other judges. Okay. The President determines the strength of a High Court from time to time depending upon its workload. Okay. Not like the Supreme Court, which has the 34 judges, 1 Chief Justice and 33 other judges. Okay, there is no particular strength of the High Court. It is determined by the President depending upon the workload. Okay. Okay. The judges of the High Court, they are also appointed by the President, like the Supreme Court. Okay. The Chief Justice is appointed by the President after consultation with the Chief Justice of an area and the Governor of the state concerned. Okay. For the appointment of other judges, the Chief Justice of the concerned High Court is also consulted. Okay. Now, the qualification of the oath and the salaries of the judges. A person to be appointed as a judge of a High Court should be a citizen of India. Okay. He should have a judicial office in the territory of India for 10 years. He should have been an advocate of a High Court for 10 years. Okay. And also, there is no prescribed minimum age for the appointment of a judge of a High Court. Okay. The Constitution had made no provision for the appointment of a distinguished jurist as a judge of the High Court. There is a requirement of a distinguished jurist that is being appointed by the President, right, for to be the judge of Supreme Court, but this condition is not being there in the High Court. Okay. A person who is appointed as a judge of a High Court before entering the office has to make the oath, which is before the Governor of the state. In case of Supreme Court, it is before the President, but in the case of the High Court, it is before the Governor of the state or some person which is appointed by him. Okay, and he has to be bear the judge of a High Court should bear the true faith and allegiance to the Constitution and to uphold the sovereignty and integrity of India, to duty and faithfully and to the best of his ability, knowledge and judgment perform the duties of the office without fear or favor, affection or ill will, and to uphold the Constitution and the laws. Okay. The salary of the Chief Justice has been increased to rupees 2.50 lakh and that of a judge to 2.25 lakh per month. Okay. Now the Constitution of India has fixed the tenure of a High Court. Okay. Has not fixed the tenure of the High Court. Okay. Just like the Supreme Court, there is no fixed tenure. In the High Court, there is no fixed tenure of the judge of the High Court. But he should hold the office for the attain the age of 62 years. In case of Supreme Court, it is the up to the age of 65 years. Okay. He or she can resign the office by writing to the President, and he or she can be removed from his or office by the President on the recommendation of the Parliament, and he or she vacate his or office when he or she is appointed as a judge of a Supreme Court or he is or she is transferred to another High Court. Okay. Now, a judge can be removed by the order of the President. The president can issue the removal only after an address by the parliament. ठीक है? And as per the Judges Inquiry Act, that is similar to the Supreme Court, the removal of the judge can be done when there is a removal motion by the 100 Lok Sabha members and 50 members of the Rajya Sabha, and it is given to the speaker admit or refuse to admit the motion. If motion is admitted, the speaker constitute a 3-member committee. The 3-member committee consists of the chief justice, the chief justice of the Supreme Court, chief justice of High Court, and the distinguished jurist. Okay? And if the committee finds the judge to be guilty, the motion is passed by the House of Parliament by a special majority to the president, and then president passes an order for the removing of the judge. Okay? Okay. Now, acting chief justice, the president can appoint a judge of an high court as an acting chief justice when the office is vacant, the position is temporarily absent, or the chief justice is unable to perform the duties. Okay? The judge of the High Court, as I told, is appointed by the president in consultation with the members of the judiciary, that is chief justice of the India and chief justice of the High Court. Okay? Okay. Now, what are the powers? Okay. Like the Supreme Court, the High Court has the very extensive and effective powers. It is the protector of the fundamental right of the citizens, and it is vested with the power to interpret the constitution. Besides this, it is also the supervisory and the consultative roles. Okay. Now, the powers include the original jurisdiction. It means the power of the High Court to hear the disputes in the first instance. Okay, not by an appeal, right? So, Supreme Court, you have to done the you have to do the appeal to hear the for the hearing, but it's not the case in the High Court. High Court is the original jurisdiction. It can extend to the following: dispute that is related to the election of members of parliament regarding the revenue matter, enforcement of fundamental right, that the case is ordered to be transferred from a subordinate court to its own file. The 4 High Court, that is Calcutta, Madras, Bombay, and Delhi, have original civil jurisdiction in cases of higher value. In all these particular cases, the High Court of India holds the original jurisdictions. Okay? Now, there is a writ jurisdiction. The Article 226 of the Constitution empower the High Court to issue the writ that include the habeas corpus, mandamus, certiorari, prohibition, and quo warranto for the enforcement of the fundamental right of the citizens, and for also other purpose as well. I told you, in case of Supreme Court, the writ can be only issued in the for the fundamental right, but in High Court, writ can be issued for the fundamental right as well as for the other purpose as well. Okay? The phrase for the other purpose refers to the enforcement of an ordinary legal right. Okay? For example, the right to property, that is your ordinary legal right. Okay? The writ jurisdiction of the High Court, that is Article 226, is not exclusive but concurrent with the writ jurisdiction of the Supreme Court, that is Article 32. Okay? Now, the appellate jurisdiction. High Court is primarily a court of an appeal. It hears the appeal against the judgment of a subordinate call. So, subordinate court में जितने भी appeal होती है, it is heard by whom? It is heard by the appellate and jurisdiction authority, that is the High Court. Okay? And it includes both civil matter as well as the criminal matter. Okay? Okay? Okay. Now, supervisory jurisdiction. High Court has the power of the superintendence over all the court. It can call for the return. It can make and issue general rules. It can prescribe forms in which books and entries are to be kept, and it can settle the fees payable to the sheriff, clerk, officials, and legal partitioners of them. Okay? Control and subordinate courts. Control over the subordinate courts. In addition to the appellate jurisdictions and supervisory jurisdictions, the High Court has an administrative control and the powers over them. It is consulted by the governor in the matter of the appointment, posting, and promotion of the district judges. It deals with the matter of the posting, promotion, grant of leave, transfer, discipline of the judicial service of the state. It can withdraw a case that is pending in the subordinate court if it involves a question of a law that requires the interpretation of the constitutions. Law is binding on all the subordinate courts functioning within its jurisdictional area, right? Okay. Now, the court of record. The High Court has 2 powers. Judgment proceeding and acts of the High Court are recorded for the perpetual memory and testimony. It has the power to punish for the content of itself as well. Now another function is judicial review. Judicial review is the power of the High Court to examine the legislative bodies and executive bodies whether they are not violating the constitution or not. Okay. If they are found to be violative of the constitution, that is ultra vires, they can be declared illegal and unconstitutional and invalid by the High Court. Okay. So the Supreme Court and High Court is similar. Okay. So this is all about today, guys. Thank you everyone.